Good morning. I'm Gary DeWaal, and this is Bridging the Week for October 21st, November 1st, and today is November 4th, 2019. A federal court of appeals agreed with the Commodity Futures Trading Commission that a district court may not require the testimony of 3 commissioners and various staff to assess whether the agency committed civil contempt in connection with its handling of an enforcement settlement with 2 food giants. Promptly following the appellate court's ruling, the relevant district court set aside the settlement consent order and indicated it would solely evaluate the existing record to determine whether to grant the defendant's motion for a contempt finding against the commission and appropriate sanctions. Separately, a law firm filed its own lawsuit against the CFTC for the agency's non-provision of documents in response to a request under the Freedom of Information Act. Unrelatedly, the House Committee on Agriculture proposed to reauthorize the CFTC for another 5 years, but also to expand the reach of potential aiding and abetting liability to reckless acts in addition to purposeful acts. FIA hosted a successful expo last week in Chicago that I attended, so I can now catch up on piles of work on my desk as a result of this and other recent travels. Let's get started. The CFTC continues to address the fallout from its handling of a consent order agreed with Kraft Foods Group, Inc. and Mandamus Global, LLC on August 14, 2019. After a federal court of appeals mostly agreed with it that a federal court judge could not require the testimony of individual commissioners and staff in a civil contempt proceeding in responding to the defendant's motion, the judge set aside the settlement and told the parties to be ready to argue their motions for summary judgment and other matters and propose a trial date during a hearing on November 20th. He also advised the CFTC he would be deciding defendant's motion for contempt and possible sanctions based solely on the existing record. Separately, a law firm filed its own lawsuit against the Commission for failing to provide documents it requested related to the settlement under the Freedom of Information Act. The lawsuit was filed on Halloween. As I've spoken and written before, this is a very bizarre matter, and developments continue to haunt the Commission. Last week, the House of Representatives Agricultural Committee proposed a bill to reauthorize the CFTC through fiscal year 2025 that includes a material expansion of potential aiding and abetting liability. Currently, under relevant law, any person who willfully aids and abets a violation of law can be held liable for such violation as a principal. As proposed by the House Ag Committee, any person who recklessly provides substantial assistance to such a violation could also be liable as a principal. In light of the CFTC's relentless prosecution of Jitesh Thacker for developing software used by Flash Crash spoofer Navinda Sarao, despite the dropping of parallel criminal charges by the Department of Justice, the proposed expansion of potential aiding and abetting liability for non-registrants is a significant red flag. Potentially holding programmers of futures trading, advisory, or even surveillance systems liable for non-intentional development of software that might be used for illicit purposes could have a material chilling effect on software development for legitimate purposes and inhibit U.S. leadership in creating new fintech approaches for the derivatives industry. Stay tuned. Finally, a federal district court in Chicago declined to dismiss criminal charges alleging violations of wire fraud prohibitions against James Vorley and Cedric Chenu related to alleged spoofing activities on the Commodity Exchange, Inc. from at least December 2009 through November 2011. Both individuals were formerly associated with Deutsche Bank and were named in a criminal complaint filed in July 2018. The defendants were charged both with wire fraud and with conspiracy to commit wire fraud. The defendants had argued that they could not be convicted of wire fraud because a violation under the relevant statute requires the making of affirmative misrepresentations, and that, even as alleged, spoofing trading does not entail making false statements. According to defendants, their orders, even if spoofing orders, entailed no representation beyond their stated terms and solely communicated an implied commitment that if their orders were accepted before canceled, they would be filled according to their terms. The Honorable John Thorpe, Jr., the presiding judge of this matter, disagreed with defendants' arguments. He wrote that omitting or concealing material information, even absent a duty to disclose, constitutes a violation of wire fraud prohibitions, quote, if the omission was intended to induce a false belief and action to the advantage of the schemer and the disadvantage of the victim, end of quote. I think I said John Thorpe. It's John Tharp. Judge Tharp claimed that when orders are placed with an intent to cancel them before execution in connection with spoofing, the intent is to create a quote-unquote false belief about the supply or demand for a commodity, so that a market moves in a direction to execute resting orders of the spoofer on the opposite side of the market to the detriment of other traders who are not knowledgeable of the spoofer's trading intent. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website at www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a nice week, and into the next edition of Bridging the Week. Ciao.